Good morning and welcome to this afternoon's Knowledge Bank. Today's webinar will be hosted by Michelle Footer, Associate at Bolt Burdon Solicitors. She will be talking you through the new commercial rent coronavirus deal. If you have any questions throughout the session, please submit them via the Q&A button at the bottom of your screen, and we will try to get through as many as possible at the end. The session is being recorded and will be available to watch back later today via our YouTube channel. I will also be sharing a copy of the slides if anyone would like to see them. That's all from me for now, and I will now pass you over to Michelle to begin the session.
Afternoon. Thank you very much for joining us today. As Vicky kindly said, I'm going to be speaking about the Commercial Rent Coronavirus Act 2022, which is a new, interesting and potentially quite complex legislation that has been introduced. It introduced a binding arbitration scheme to resolve rent arrears which have accrued during the pandemic periods. The use of this legislation is actually going to be quite short-lived, which I'll discuss a bit more later on in the presentation, but it's sort of short and sweet, but it is very important that both landlords and tenants understand what their sort of rights are and what they can do at this stage. I'll take some questions at the end. I'll do my best to answer those. Just bear in mind it is new legislation and it does leave a lot of questions unanswered in itself. So try my best to answer them. It might be that, you know, as the legislation gets going and gets into practice, that these questions sort of will be answered by sort of case law. So just bear that in mind. So just moving on to what we're going to discuss today. So I'm going to talk about what the purpose of this new act is, and why it's been introduced, who the new act will apply to, what period of rent arrears are covered by the act, and what will be decided at an arbitration. Have a look at a few other considerations and talk about the costs element of it. So just to start with, the government recognised the need for legislation early on in the pandemic. So instead of waiting until that legislation was put into force, they decided to come up with something called the Code of Practice. So this was to assist in dealing with the arrears as they were arising during the pandemic period. It was a voluntary guidance only, but it did help landlords and tenants to sort of navigate the period, which obviously was a very difficult period and a lot of pressures on both parties. Sort of not helped by the fact that the government also introduced a lot of restrictions on enforcement action. There was a moratorium on forfeiture of leases, restrictions on the recovery process under the sort of CRA, and restrictions on winding up petitions. So while the new original Code of Practice was useful, the government still recognised that an actual legislation, it was. So why was that? You have to ask yourself. So the government estimated that the disruption caused by COVID had resulted in sort of £9 billion in rent arrears having accrued by March 2022. So it was clear from this to everybody that intervention was necessary to avoid sort of mass scale sort of litigation and business insolvency, particularly when the restrictions on enforcement were lifted. Courts were already seeing this, and there was lots of cases going to the court, and sort of the courts were already very busy and backed up due to the pandemic. So they had to take some steps to deal with that, and obviously to make sure that there wasn't this mass scale sort of insolvency. The most well known of the cases is a case called London Trocadero versus the Picture House Cinemas, where London Trocadero commenced a claim against Picture House for the unpaid rent that had accrued during this period. And this was in 2021, so before this legislation came into place. The defence put forward by Picture House was that due to the sort of unforeseeable nature of the pandemic, that the court should be able to interpret into the lease a clause which allowed them not to pay their rent for this period. And then the court threw that out, said basically it wasn't a defence. the tenant Pitch House had to pay their rent for this period. So it shows us that the courts are very much in favour of landlords here, and not least because there was a lot of help given to tenants during these difficult periods with sort of grants and sort of funds from the government themselves. So it's just interesting to note. The British Property Federation also carried out a study, and they found that of the rent arrears that had accrued during the pandemic period, 23% of them remained unresolved, and 14% of tenants were failing to engage with their landlords on these arrears. So it did leave quite a vast sort of sums of money outstanding, and obviously potential litigation sort of sitting there waiting to happen. So what the Act does, it puts in place a structure to bring about a dialogue between landlords and tenants, so that they can reach a resolution, and so that these rent arrears can be resolved. What the government have said, though, is, and they've been very clear on this, is that it's not a way for a tenant to escape liability. If they can afford to pay rents, then they should do so. It's a way of reaching a resolution which sort of allows both parties to continue on in business, but it's not a way of just saying, well, the pandemic was here, I shouldn't have to pay rent for that period. So that they have been very, very clear on that. So it's going to move on now to when is it being introduced. It came in, actually, it got royal assent on the 24th of March 2022. And before that, obviously passed through the House of Commons, where significant amendments were made. So it's now a legally binding arbitration process. So that's obviously good news. So, alongside that, they have introduced a commercial rent code of practice, which replaces the old code of practice, which was the initial guidance, which was in place from June 2020. This guidance came into place from the 7th of April 2022. It sits alongside the legislation and clarifies what is statutory, what parties have to do to negotiate on these rent arrears. So that's just interesting. It's quite comprehensive and quite a good read if you're looking for some sort of particular information. So who does this Act apply to? Who can benefit from it? Who can take part in the arbitration process? So it's business tenancies as defined by Part 2 of the Landlord and Tenant Act 1954, which is essentially tenancies which are occupied by the tenant, properties which are occupied by the tenant for the purposes of their business. There's been much debate and much discussion about what tenancies aren't included and what tenancies can't take advantage of the new scheme, particularly surrounding group companies, sublets, franchises, and also tenancies that are contracted out of the Landlord and Tenant Act 1954, were these intended to benefit or not. So the government, in the code of practice, which I've just referred to, has actually gone into a lot of detail on what tenancies are and are not included. So if you're looking for something specific, then sort of go there. Just sort of generally, I'll just take you through them, the sort of four main ones, so that you know. You've got the group companies, sublettings, and franchises. So there was a lot of debate about what leases would be included here, and the government have categorically confirmed that only the business tenancy under which the tenant occupies is to be included. So tenants who've wholly sublet the properties, they can't take advantage of the scheme. So that does help clarify things for a lot of people, although there are quite a number of sort of disappointed parties there. So moving on to contracted out tenancies, there was much debate whether these were going to be included in the protection of the Act or not. That would have left sort of a vast amount of leases which weren't going to be covered. So as this was having its passage through the House of Commons, parties were sort of getting involved, putting their, big companies were putting in their sort of input into this, to the point the government confirmed categorically that these tenancies would be included. So this cleared up sort of all the confusion, and that's was clearly stated in the legislation itself and in the guidance, which is good. So I'm going to look at what period the Act applies to. So the rent arrears that are covered are those that were incurred when a business was subject to or affected by the mandatory closures or restrictions on the use of the property during the pandemic. So the period in question is the 21st of March 2020 to the 18th of July 2021. So depending on how a business was affected by the restrictions decides what the protected period is for that business. And when you decide what the protected period is, you can work out what the amount of the protected rent is. That protected rent is then ring-fenced so that the landlord can't take any action on it until the referral has been made to the arbitration and a decision made, or the period has passed and the tenant or the landlord doesn't make a referral, and then it is no longer protected. So it's very important to take these steps in the time periods, which we'll discuss in a moment. So there are some things which are clearly included within the protection, and some things which aren't. And there are some sort of more grey areas where people have to read the legislation and the guidance quite thoroughly to ascertain whether or not they fall within the sort of protected periods, whether they can take advantage of this scheme. So things like venues which had to open and close regularly during the pandemic, they seem to be able to take advantage of the scheme for the entire period, sort of the entire protected period for the dates that I referred to. Venues also which were limited in usage, so for example, restaurants and pubs which had to have restrictions on the number of people who could dine or the number of households who could mix, they are also included. And shops. So shops were obviously included, but only to a certain point. So 12th of April, I think it was 2021, would mark the end of their protected period because they were allowed to open and trade freely again. So they wouldn't be able to claim that the rents thereafter should fall within protected rents. So more interestingly is what isn't included. What businesses can't take advantage of this arbitration scheme. So perhaps not unsurprisingly, businesses who continue to trade during the sort of the pandemic period and were not forced to close, they obviously aren't entitled to take advantage of it. But perhaps more surprisingly are businesses that were not required to close, but who were adversely affected by the closure of, say, other businesses, or where they decided to stay closed because it wasn't economical for them to open. They aren't covered by the protection of the Act. But whilst they're not protected, whilst these sort of types of businesses aren't protected, what the government have said is that they are strongly encouraged to try to reach a resolution using the principles of the Act, using the guidance to negotiate a settlement. So they will be expected, if any cases are brought to court, they will be expected that they have tried to resolve it. And I would imagine there'll be some cost penalties for parties who wouldn't engage in negotiations at an early stage, even for these types of businesses that don't necessarily fall under the protection. So that's just something to bear in mind. So once you've established what the protected rent is, that amount is ring-fenced safely to allow the arbitration process to go ahead, or until the end of the period, which we'll discuss in a little bit. No recovery action can be taken on those sums, and no enforcement action either. What tenants need to be careful of during this period is that they will probably still be making payments of rent now. These rental payments they need to specify where they're going to be attributed to. If you don't specify where your rental payment should fall, the landlord can choose to apply it to whatever outstanding rent there is. So he would apply it to a protected rent period, meaning that the tenant would lose their protection for that portion of the rent. So that's just something to bear in mind there. So once you've decided that you have protected rent, what happens next? So how to make a referral to an arbitrator. So the first thing to understand is that a referral can be made by either a landlord or a tenant. It must be made before the 23rd of September 2022, being the last date for a referral, unless, of course, that period is subsequently extended by the government. But at the moment, it doesn't seem there are any plans for that to happen. Before that date, though, there are certain things that would need to be done to allow you to make a referral. And those are timed steps. So landlords or tenants mustn't leave it too late to start working on this process if they intend to make a referral to an arbitrator. I'll chat through what the pre-arbitration steps are in a moment, but let's just say we've concluded the pre-arbitration steps. One of the parties would make a written application then to an arbitration body approved by the Secretary of State. And that would be what kicks off the process and starts matters moving forward. We'll just turn back to what steps must be taken before that referral, that written submission is made to the arbitrator. So firstly, it's expected that parties should already have been engaging in pre-action discussion. If they haven't been, they're going to encounter problems with the process going forward. And I would imagine there would be some sort of significant criticism of them. After sort of the initial pre-action correspondence has taken place and they've decided that we've got to a point where they can't make any more progress, they need to send what's known as a notice, a sort of notification of intention to the other party. This essentially is a final offer for what they can afford to pay and what period they're going to pay it over. Once that offer is sent, that notification is sent, they have to wait 28 days for a response before referring it to an arbitrator. If they receive a response, they have to wait a further 14 days. So you can see that you're looking at a month and a half there where of things, timed steps which need to be taken before a referral can be made. So you're looking at sort of starting these steps by sort of mid-August at the latest in order to make the referral by the deadline of the 22nd of September. But even then, I'd say you're cutting it very fine. You should be looking at an earlier date. You're starting the process now. So the sort of the warning there is don't leave it too late. So the referral has been made. What powers does an arbitrator have? So an arbitrator receives the referral, looks through it, and firstly decides whether or not you're entitled to use the process. If you're not, just dismiss the referral outright. If you are, then they have various powers to either grant relief on all or any of the rent arrears that have accrued during the period, reduce or remove sort of the interest element of it, or allow more time for the tenant to pay the landlord. I mean, these powers the arbitrator have, they are quite extensive. They were very extensive. I mean, they have the power, they could have the power if they wished to wipe the slate clean, essentially, to say that the tenant doesn't have to pay any of the arrears. In practice, that's quite unlikely because they have the obligation to balance the interest of the landlord and the tenant whilst considering the provisions of the Act. But that just shows you how extensive their powers are and what the government have granted to them. They're only allowed to decide cases where the defence to sort of the non-payment of rent is pandemic related. If it's anything else, that has to be decided in the normal forums, usually by the court. Once the arbitrator makes a decision, that is binding on the parties, but it's not considered the same as sort of case law is. So it's not authoritative, and it's not binding on other arbitrators. It's just specific to this one case. So we're going to look at now what actually the arbitrator has to look at, what he has to decide at the arbitration, or what sort of heads that he has to review. So the two considerations for them, which we'll break down into a bit more detail in a moment, are the viability of the tenant's business and what proposals have been submitted for resolving the dispute so far. Starting with the viability of the business. The arbitrator has to consider for the business what its future is. It means different things in different businesses, of course, what viability means. It's not defined by the Act because of how different it is across different industries and different businesses. But the guidance does provide quite a lot of helpful sort of tools and guidance to sort of help the arbitrator consider in different situations what would be a viable business. But the key question for them, the key question they have to answer is, putting aside that protected rent, whether the tenant's business has or would have the means to meet the obligations and to continue trading now or in the foreseeable future. So it's not a question of whether the tenant's business is insolvent. That's all very important to understand. So if the arbitrator considers all of that and decides that the tenant would have a viable business if they put aside the protected rent, then the arbitration will progress on to the next point, which is the consideration of the proposals to resolve the outstanding rent arrears. So what does the arbitrator have to consider here? So the main aim is to preserve the tenant's business, but not at the expense of the landlord's business or solvency. So whether tenant can afford to pay in full, they should, and without sort of unnecessary delays. The arbitrator has to consider any information that's available to them in relation to the landlord's solvency, including their ability to make their onward payments, but also they have the ability to consider other tenancies which form part of the landlord's portfolio. It's quite important, and we'll discuss that a little bit more going forward. So the arbitrator needs to check whether the proposals are consistent with Section 15 of the Act. When I say the proposals, I mean the submissions that were made when you made the referral to the arbitrator. So the Section 15 of the Act requires that any award that the arbitrator makes aims to preserve or restore and preserve the tenant's business, but not at the expense of the landlord's solvency. So you can see that it's a very finely sort of balanced question. When looking at this, the arbitrator must also look to the financial information provided and make sure there hasn't been any manipulation of the figures to assist either party in sort of achieving a more favourable outcome. So sort of turning to these submissions, these are very important, the submissions that were made to resolve the arrears. If both parties submitted a proposal at the outset when the referral was made, and both are consistent with the Section 15 principles, then the arbitrator will review these and will select what he considers to be the most consistent proposal. And that's the award that he will make. If both parties submitted a proposal at the beginning, but only one party's proposal is consistent with the Section 15 principles, then the arbitrator will have to select that proposal and make an award based on that. If both parties submit a proposal, but neither are consistent with the principles of Section 15, then the arbitrator can make whatever award they see fit. In a situation where one party submits and it's a consistent proposal, that's the award the arbitrator will make. And then in a situation where one party submits which isn't consistent with the Section 15, then it's again whatever award the arbitrator wants to make. So you can really see from that how important the original submissions are. You've got to get that right. They need to be realistic or they're going to be disregarded. The landlord and the tenant need to consider what they can actually afford or what they can afford to accept, and give a lot of thought to that, and base that on sort of solid evidence. Otherwise, this would run the risk of your submission being entirely disregarded and the other party's submission being accepted. So it is very important. So turning to what you can do to sort of bolster your case, or what evidence is required to be submitted with those submissions to assist the arbitrator in making a decision. So firstly, looking at the viability point, the evidence for this has to be collated and put together with the submission. So companies need to look at the evidence which will support, sort of show their assets and their liabilities, show previous rental payments that they made, show the impact that COVID had on their business, and then any other relevant financial information. So that can come from internally within the business, from accountants or any third-party suppliers, anything that will assist in showing the viability of the business. That will need to be submitted with the submissions. Then the proposal itself, which obviously gets submitted at the time of the initial referral, that has to sort of include all those points, but also your proposal for payment, and it has to be accompanied with a statement of truth from one of the company's directors or from an individual if it's that case. So the arbitrator has all the information now. What happens next? Will there be a hearing? Now, the government intended that these referrals would be dealt with on paper. If a referral is submitted on paper, then a decision must be made by the arbitrator as soon as reasonably practicable. They don't have to request any further information, and they can just decide based on what is put before them. So I would say the majority of cases will be dealt with like that. However, parties can request a public hearing. So if they request a public hearing, that hearing has to be heard within 14 days of the request. It's limited to 6 hours in length. And then after that hearing, the arbitrator has a further 14 days to make their decision. Public hearings have raised a lot of concerns. Obviously, not many businesses are going to want to have a public hearing where the viability of their businesses are going to be discussed openly. And that could impact their business going forward in itself. Suppliers can become nervous, many things like that. I think it's going to be a sort of a rare case that has a public hearing. But there are benefits to a public hearing for certain parties. So those parties are parties with multiple properties, landlords with portfolios, because the landlord can make submissions to have a number of cases heard together and joint decisions made in relation to various properties with arrears on, because the viability of their business is obviously going to be affected by a number of different cases. If you have 10, 20 properties, obviously, if rent arrears are reduced on all of them, then obviously that may have a significant effect on their viability going forward. I think it's cases like this which are going to be heard by public hearing, but it's one of those things that we'll see who opts for that and who doesn't. So what happens then? Once the arbitrator has considered everything, he has to make an award, a detailed award of his findings and what is going to happen next. That award is final, you can't appeal it, and it's binding on both parties. And it also affects the terms of the lease. So it serves to actually alter the terms of the lease in relation to those protected debts. So that's always interesting to know. So that's the process in a bit of a nutshell. There's been some other considerations and things that you need to think about when making a referral or when considering whether or not you fall within the protections of the Act. So the first is cases which would have applied, which would have had a sort of protected period, protected rents, but landlords and tenants have already reached an agreement, as the government have been encouraging all along the parties to negotiate. Many parties have already come to a conclusion and decided how these arrears are going to be resolved. The government's made it very clear that it's not another opportunity for landlords and tenants to sort of reopen agreements which have already been made. Agreements being made are binding and continue to be so. But that said, court orders made after the 10th of November 2021 in relation to protected rent can't be enforced, and ongoing proceedings relating to protected debts are stayed to allow the landlords and tenants the opportunity to go through the arbitration scheme. And then we'll move on to, coming to the end, we'll move on to costs. Who pays the costs? This is going to be likely, the cost of this process is going to be very high. If you think about all the things that need to be done, sort of the pre-action steps that need to be taken, the submissions that need to be made, the evidence that needs to be collated to support your case. You're likely to have to get evidence from other parties, accountants. It's going to take sort of internal parties a long time to sort of assess the figures and decide what could be paid and what they can reasonably or realistically sort of predict for their business going forward. That's sort of a heavy cost. There is going to be no cost awards in these cases, so that means that a party is required to pay their own costs and to share the costs of the arbitrator between them equally. The idea behind that is to encourage people to settle them early, to settle them before it gets to that stage. But there will be a lot of cases that don't, and parties need to be aware that they will have to meet their own costs. So now turning to any questions.
Doesn't look like we have any questions in at the moment, Michelle.
No, that's absolutely fine. I've obviously provided lots of information for people to digest.
It is, yeah, and it's such a new kind of topic, I suppose, that it's more taking it in rather than asking too much at the moment.
That's right. And I mean, the guidance is there. I mean, the code of practice, it's a big read, but the answer will likely be in there. So that's where you should go if you have any specific questions. But I left my email address on the final slide as well, so I'm more than happy for people to come with.
Yeah, of course. I'll be sharing the slides with everybody this afternoon with a copy of the recording. So if anyone wants to get in touch with you directly for any more advice, then they'll be
more than happy to try to answer any questions.
Okay.
Wonderful.
Okay, well, thank you so much, Michelle, for joining us.
Thank you.
Thank you to Bolt Burdon too, obviously, for hosting the last 3 webinars over the last week. Really grateful. They've all been brilliant.
I think we enjoyed it. Thank you.
Thank you. As I mentioned, everyone else, thank you for joining us. The recording will be available later today, and I will send out a copy of Michelle's slides. If you want to join us for any more webinars, then please take a look at the schedule on the News on the Block website, where you'll be able to register. Otherwise, thank you so much for joining us this afternoon, and I will see you all again soon. Thank you, Michelle. See you later.
Thank you. Bye.
Bye.